Hello. Um, my name is Mr. Ybarra. I am going through the lecture for Chapter 6 in America's Courts. And we're going to be discussing basically prosecution or the prosecutor today. Um, so the origin. Oh, by the way, as a reminder, if you haven't already done so, what I would recommend you do is print out Chapter Six PowerPoint from Canvas and utilize that PowerPoint to follow along on this lecture because that is what the lecture is being based off of. And then you can highlight areas that you feel are going to be important, and you can take notes in the margins and that kind of stuff. It'll make it easier for you to study for all of your exams and some of the other assignments that you may have in your modules. Again, I'm sorry. Origin of the public prosecutor. So, in some respects, the prosecutor is the most powerful official in criminal courts, more than judges and defense attorneys. They're responsible or have the ability to make decisions and have input from the initial arrest all the way to the final disposition. Um, Not as much in sentencing, but all the way to the final disposition. Prosecutor determines the extent in which discretion will be used in the prosecution of that case, the type of bargains that are going to be struck, and the severity of the sentence to be imposed, especially when you're talking about plea bargaining. So there's a lot of authority. A lot of people think that the judge is and while it is true, the judge is the primary, they're the ones who maintain the order of the court. With regards to the actual case itself, the prosecutor is the one that maintains the most authority. Under British common law, private citizens were permitted to act as prosecutors as a means of facilitating retribution. I remember in your Crim 1 class, we learned that that is what the criminal justice system ideology is completely based off of. Lex talionis, an eye for an eye. This tradition of private prosecution was carried over in the Americas, in the American colonies, through the 1600s, even into today. So in 1704, Connecticut established the first statutory scheme for public prosecutions, and in 1711, Virginia established a formal system of county prosecuting attorneys. So you may see that again. Interesting enough, some states still allow private criminal prosecutions where crime victims can hire their own attorneys to criminally prosecute a case as long as the local public prosecutor retained ultimate control of the case. So again, we still, to this day, I mean, it's a few and far between, but it still is used. However, there are some concerns, obviously, because there may be conflicts of interest. There could be vindictive or malicious prosecutions. Or there could be corruption, and obviously there could be due process violations because people who don't know courtroom process and the rights that are afforded to a person who's being criminally charged or criminally prosecuted, they may not get all those rights. So that's one of the reasons why private prosecutions are becoming kind of extinct, if you will. Quasi-public prosecutions, where a practicing attorney, private attorney, is permitted to act as a part-time prosecutor, is still sometimes used, though. So as opposed to having a non-lawyer acting as a prosecutor, they'll have a private practicing attorney act as a prosecutor in some instances. And generally, we're talking about rural instances. So, so what does a prosecutor do? What is their responsibility? So the role of a prosecutor is they are the bridge or the connective tissue, if you will, between the police and corrections. So they influence both areas with their decisions with regard to how they're going to process a case. According to Justice Robert Jackson, the prosecutor has more control over life, liberty, and reputation than any other person in America. And obviously, if a prosecutor makes a decision to not bring a case to trial, then even a judge doesn't have that ability to bring that case up. So the prosecutor is the one who makes that determination. In some areas, a prosecutor has an influence in the initial appearance. They have influence in bail recommendation. the charging of the defendant, obviously, the preliminary hearing, because they are the ones that present. In a grand jury, they have some, but grand jury cases are largely, where they are, where they have some influences, where the grand jury essentially rubber stamps what the prosecutor would do in a preliminary hearing with regard to indictments, either a true bill, which is, and we'll get into what a true bill and no bill is later on. An arraignment area, they have influence in arraignments, they have influence in discovery, in suppression motions, essentially when they're talking about the introduction of evidence, plea bargaining, obviously in trial, sentencing, and appeal. So there are instances, and we can even go further where an individual has went through the sentencing process, they've already been in custody, and they're about to go through parole. There are some instances where prosecutors actually have influence on whether or not an individual is going to even be granted parole. So there's quite a bit of influence that prosecutors have. In 1935, the Supreme Court of the United States spelled out limits imposed on prosecutors by their obligations as officers of the court. So the court said that prosecutors may prosecute with earnest and vigor. They should do that. However, while he may strike hard blows, he is not at liberty to strike foul ones. And what that means essentially is that they expect the prosecutor to work in earnest to get the prosecutions, because the state / the people deserve that. If they write a law and that law is violated, the state has a right and the people have a right to have somebody vie for them to make sure that the law isn't violated. But in that same breath, they can't just win at all cost. There are rules of conduct that they have to follow. So they have to refrain from improper methods calculated to produce a wrongful conviction, as it is to use every legitimate means to bring about a just one. So they can't withhold evidence. They can't, there's a lot of things they're not allowed to do, and things that they should do as prosecutors. That has a tendency, though, to cause a great deal of conflict within the prosecutor's office, because you have to remember we work in an adversarial system. So if a prosecutor, because there really isn't any other major way to I don't want to say rate, but for lack of a better term, to rate a prosecutor's ability to get these prosecutions, to get these convictions, they have to use the amount of convictions as a measuring metric, as a measuring stick. And so with all that pressure to get these convictions, sometimes it can lead to prosecutorial misconduct, and that has that can be and is a problem within the courtrooms. So it's one thing again to work hard to try to get these convictions, but prosecutors have to remember that while ultimately they are trying to get the prosecution, the main ultimate goal is to uncover the truth. Right. All right. Charging decisions. So charging decisions, of all the discretionary decisions prosecutors make, this one, the charging decision, is the most important. So remember that. You may see it again. And that means whether or not they're going to file a charge. Supreme Court has noted that as long as a prosecutor has probable cause to believe that an accused committed the offense that they are being charged with, which is defined by statute, the decision whether or not to prosecute and what to charge or what to file and bring before the grand jury generally rests entirely at his or her discretion. So prosecutors have broad discretionary powers with regard to what cases go before the court. Focal concerns theory, and you'll need to know this, is the perspective that seeks to explain sentencing disparities on the basis of three primary focal concerns: blameworthiness, protection of the community, and consequences of the sentencing decision. All right, so blameworthiness, protection of the community, consequences of the sentencing decision. So that is the three sentencing disparities that focal concerns theory focuses on. Legally relevant factors of the case that prosecutors must consider include seriousness of the offense, the strength of evidence, culpability of the defendant, degree of the harm, the degree of the defendant cooperated with a criminal investigation, and the likelihood that the prosecution, in somebody else's jurisdiction. So there's a lot of things that prosecutors have to look at when they're going to make a decision to charge or not charge somebody. Evidence shows that prosecutors also consider extra legal factors, and we talked about that, what extra legal factors are, and those are factors that don't pertain or not germane specifically to the case, and things that are, in some cases, can't be changed by either the victim or the witness. So that would be characteristics of the offender, the victim or key witnesses, race, ethnicity, economic status, social status, age, their gender, that kind of stuff. So sometimes prosecutors do consider these, and sometimes they're actually needed to consider. They need to consider them. And somebody who if they have the person who's going to be charged is a mom, the case was low level, children are young, they don't have any other mechanisms to watch the children, then there's a possibility that consideration would lead the prosecutor to try to get a community correction sentence as opposed to an incarceration. All right, number 4, prosecution in federal courts. So the United States Department of Justice is the prosecutorial arm of the federal government. You will need to know that. You'll see that again. It's the largest law firm in the world. So the United States Department of Justice. And the head of the DOJ is the U.S. Attorney General, who is the member of the President's Cabinet. And for those of you who don't know, that's U.S. Attorney General right now is Bill Barr. In terms of prosecution, there are 3 entities and departments in the U.S. Justice Department. You have the Solicitor General's Office, Criminal Division, and the U.S. Attorney General's Office. And each one of them has a responsibility. So the Solicitor General's primary responsibility is to represent the executive branch before the Supreme Court. So they coordinate and present appeals to the federal government for the Supreme Court to review. And that would be like if the issue with regard to, and today, the issue with regard to President Donald Trump and his ability to, or his authority to take military funding and move it to build a wall at our southern border. There are a number of different public and private entities who don't believe that's the case. They file court, and if that moves all the way up to the Supreme Court, the Solicitor General's office would be the one that represents the executive branch, which would be the President of the United States. Central Division develops all of the law enforcement policies over the federal criminal cases except those assigned to other divisions like the JAG, which is the Office for Military Justice. Central Division attorneys prosecute nationally significant cases, especially acts of domestic and international terrorism. So these are federal criminal case. This is a law enforcement division that deals with federal criminal cases that are significant in nature. And then the third entity or department in the Department of Justice is the U.S. attorneys, and they're the principal litigators for the U.S. Attorney General. So they are the, if you will, deputy U.S. attorneys. They are appointed by the President of the United States with the advice and consent of the Senate. They have 3 statutory responsibilities: the prosecution of criminal cases brought by the federal government, the initiation and defense of civil cases in which the United States is a party, and the collection of debt owed to the federal government. So they act as prosecution, they act as defense in civil cases for the United States, and they also collect debt owed to the federal government. So those are the three arms of the U.S. Department of Justice, or three departments, if you will, and what their responsibilities are. All right, prosecution, that's for the federal government. So now we're going to move to states. So we have prosecution in state government or state courts. The state's chief legal enforcement officer is the state attorney general. And here in California, the state attorney general is Xavier Becerra. And his primary or their primary duties include providing legal advice to all other state government agencies. They also represent the state in court where state actions are challenged. And the state attorney general position maintains the chief law enforcement official of the state, although they don't have a lot of authority over local criminal procedure, right? So that would just be state. Chief prosecutor of the county, also called the district attorney. They're also called the county attorney, commonwealth attorney, prosecuting attorney, and they're the chief law enforcement official for a community, generally a county. There are currently 23,030 chief prosecutors in the United States, and 95% of them are locally elected officials who typically serve 4-year terms in office, and you may see that again. Local prosecutors are attorneys who represent local governments, for example, in cities and counties and lower courts, and they're identified as city attorneys. They argue for the government or for the people on initial appearance, on bond hearings, and in preliminary hearings. So those are the actual the listing of the prosecution in state and local courts. All right, prosecutor's office at work. So the primary, you'll see this again, primary workhorse of a chief prosecutor's office is the assistant district attorney, also known as the deputy district attorney. So those men and women are the ones who you will see in criminal court cases on a regular basis, moving in and out of the courtroom. They're generally speaking, they're typically newly graduated attorneys just leaving law school and entering into public service. But there's a large turnover as a result of the huge caseloads that they have. However, the average time that they spend as deputy district attorneys is 6 years on average. One of the major issues with newly graduated attorneys becoming deputy district attorneys is their lack of familiarity with the actual courtroom procedure, and that's what we talked about, the courtroom work group and how well they assimilate into those work groups and kind of learn what the processes and procedures are. So many of these new attorneys are referred to as junior deputy district attorneys, and they are just learning codified law, which is statutory law, and criminal procedure within the courtroom. So they learned all this stuff, but have never actually seen it work inside the courtroom itself. So they know what statutes are, they know case law, they know, but they don't know a lot of application. And that again, that comes with time. It's one of the areas where you're going to see a lot of OJT, on-the-job training. All right, promotions and supervision. Promotions, are related to office structure. So small offices usually use vertical prosecutions, where one prosecutor is assigned the responsibility of that case from the intake to the case all the way through the appeal. And then promotion occurs when the attorneys are assigned more serious cases. So at the very beginning, these deputy district attorneys, they are assigned low-level misdemeanor cases. They go all the way through from intake to appeal. And as they become more familiar with courtroom procedure and they get comfortable in that courtroom work group, their promotion, they move to more into the felonies, and then again into the the more the public, where they call them PIC cases, public like public notoriety, public information cases. In larger offices, promotion is based on the horizontal prosecution, where prosecutors are assigned specific functions in the court process. So, like in the very beginning, you might have the new deputy DA, and they'll deal with initial appearance and bond, the bond hearing. They may deal with the arraignment, or they may argue for the preliminary hearing. And as they get more competent, then they will move to the trial arena, and where they will actually prosecute the actual trial component, all the way through sentencing. So smaller offices, generally they assume the case in its entirety, and the larger offices, it goes through an assembly line process, where at the very beginning of that assembly line, you're going to have the newer attorneys, and at the end of that assembly line, when things become real serious, when it actually goes to trial and goes to sentencing, you're going to have the more seasoned prosecutors. Assistant district attorneys are supervised by a section head. However, they still maintain a fair amount of discretion and autonomy with their cases. However, some prosecutors, chief prosecutors, have attempted to exert greater supervision by adopting a rigid system of office policies, such as minimizing or forbidding charge reduction for some types of defendants. And you'll see this in the larger offices. Remember, we talked about if they do that assembly line, only the person at the very back end is going to be able to make any decisions or do the plea bargaining, that kind of stuff. Up in the front, they're not going to have a lot of autonomy there. So in the smaller offices, you may see that. Okay. Prosecutorial ethics. So ethical issues facing public prosecutions differ from those of defense attorneys. Not only do they have to represent the victims of crime, the people, but they also represent the public at large. The American Bar Association notes that the duty of the prosecutor is to seek justice and not merely to convict. And remember, because we talked about the idea that they are essentially graded or ranked on their convictions, that's a really hard thing for a lot of the prosecutors to deal with, right? I mean, the more convictions they have, the better they look on paper, but sometimes the idea of justice is put to the wayside. Prosecutors enjoy absolute immunity, which is immunity from civil lawsuits, civil liability for actions taken in connection with their role as a prosecutor. So we talked about the two different types of immunity in our Crim 1 class. Absolute immunity is exactly that. It's all immunity from any civil lawsuit or any civil liability with regard to the actions. And then qualified immunity, which is what law enforcement has, is a lesser degree of immunity. However, when prosecutors are not acting as government advocates in a judicial phase, they also, when they're not actually in the courtroom, they do fall back to that qualified immunity. So in that instance, if they decided they were going to do a press conference, so they had a media contact for advising law enforcement, they only have qualified immunity for their actions there. And qualified immunity, again, like I said, is partial immunity from civil liability for acts within the scope of their professional duties and only when acting in good faith, that they're not violating any law or any ethical rule or any department procedure. So when they're actually in court, absolute immunity. However, when they're acting as a government advocate in some other phase of the criminal justice process and not necessarily within the courtroom process, that immunity drops down to qualified immunity. Prosecutors have specific ethical obligations in the courtroom process, which include, in part, disclosing exculpatory evidence. And we learned earlier in Crim 1 that exculpatory evidence is evidence that would be used to minimize the culpability of a defendant or to excuse their culpability. Avoiding conflicts of interest and refraining from any behavior that would interfere from fair administration of justice. So these are the legal obligations, and we can see how they have, there is a push and pull with regard to ensuring that they maintain their ethics during the prosecutorial phase of the courtroom process, but in the same breath also, go after these the defense, the people who are being prosecuted vigorously, and sometimes those two don't work hand in hand. Okay, the prosecutor and the courtroom work group. We learned earlier on that the prosecutor is one of the three primary actors in the courtroom work group. Again, judge, prosecutor, defense attorney. The prosecutor, based on some researchers, the prosecutor is probably the most important member of that work group. The responsibilities include setting the agenda for the judge and the defense attorney by exercising discretion in cases. So what type of plea agreement to accept and the recommendation of sentences. So that's a lot of power, a lot of authority. Again, we learned that the judge controls the overall dynamic within the courtroom, the tempo of how the courtroom operates, but nothing gets to that courtroom without the prosecutor's okay. Because remember, the prosecutor is the one who makes the decision on whether or not that case is going to go forward. In order to be successful in the courtroom work group, the prosecutor has to stay within shared norms of that work group. And we talked about the formal and informal work group process earlier. Successful prosecutors have to know and work within the judge's tendencies and which defense attorneys can and can't be trusted. So remember we talked about the plea bargaining process. It's the major mechanism. It is the primary mechanism for adjudicating cases all the way through felonies. And if you don't have a really good rapport with your defense attorneys that are working within that work group or a good rapport with the judge, it's going to be significantly more difficult for you to get the convictions that you're tasked with getting. All right, political styles and expanding the domain of the prosecutor. So although in theory prosecutors should be free from political influence by virtue of being elected, they're really not. A study of 9 prosecutors' offices revealed that there are 3 types of political styles with regard to being a prosecutor, and you need to know these, all right? So the first one is the office conservator, the second one is a courthouse insurgent, and the third one is a policy reformer. So office conservator, courthouse insurgent, and policy reformer, and we'll go through each one of these. So office conservative style accepts whatever the status quo is. So if you're the new guy, the FNG, for those of you who don't know what an FNG is, it's the fucking new guy. You're the new prosecutor that comes in. Newly elected prosecutors adopt this style. They don't really want to push for any change, even though they might want to have some. They just adopt whatever policy or procedure, either formal or informal, once that in that office and in that courtroom work group. The next one, prosecutors who are really dissatisfied with the status quo, they come into these offices. They're considered courthouse insurgents. So these are the ones who will basically be in your face. I don't like the way this is done. This isn't the way it shouldn't be done. They don't shy away from any conflict, open or closed, and they don't hesitate to make any changes within their purview within that work group, within their own offices or the areas that they have control of within the courtroom. So these would be the courthouse insurgent. And the last one, the policy reformers, they're also dissatisfied with the status quo, but however, unlike the courthouse insurgent who goes in and starts banging heads, they're a little bit more cautious in their approach, and they try to make changes through time with regard to negotiation and compromise. And in a survey of about 225 prosecutors, 66% cited inadequate police preparation of crime reports as the main reason for acquittal and dismissal of cases. Here in Fresno and Madera counties, we in parole had the prosecutors contact us on a regular basis to essentially coach us through what needed to be presented within our incident reports / arrest reports. And many prosecutor offices will do that on a regular basis. And we found that when they work hand in hand with law enforcement, they get more complete presentation of evidence in the courtroom, and their conviction rates go up significantly. Efforts to improve police and prosecutor relationships should include open communication between all these departments about specifically how to complete these reports, but also about the process of the case from when the report was completed all the way through the sentencing. Because again, law enforcement, while we go through a number of different arrests and submit these reports, we also try to maintain some information, because obviously we have to go in and testify when these cases go to court. So we try to maintain contact with the prosecutor's office to ensure that the information that we've submitted was germane to the case, and was useful, and also that that this person who's being charged is going to be sentenced fairly, and that way, in law enforcement, we won't have to see this guy or lady again for any extended period of time. And when we do, they will probably be under some type of community correction system, either probation or parole, or we have a little bit more access there. All right, well, that concludes the presentation lecture for the prosecution, Chapter 6. If there's any questions, issues, comments, concerns, feel free to give me a call or email me, and I'll be more than happy to address any of your concerns. With that, I bid you a good day, and we will see you in Chapter 7.